This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we again explain why it is not nice to lie to your insurance company and why a material misrepresentation on an application for insurance becomes a defense to any claim presented, because lies on applications for insurance eliminate coverage for a claim. Magna Tyres USA, LLC appealed the summary judgment in favor of Coface North America Insurance Company and against its complaint of breach of contract and request for declaratory judgment. In a case entitled Magna Tyres versus Coface, the United States Court of Appeals for the 11th Circuit on April 10, 2025, determined the effect of a material misrepresentation on an application for insurance. Magna Tyres USA obtained coverage under Coface's international credit insurance policy to cover the credit it extended to its customers. Coface's agent completed and submitted the insurance application to underwriting before returning it to Magna Tyres USA for signature. He wrote that if there is a section that isn't completed, then that means it doesn't have to be completed, and asked to sign if Magna Tyres USA did not want to make any changes. Michael de Ruijter, Chief Executive Officer of both Magna Tyres Group and Magna Tyres USA, signed the application. Magna Tyres USA answered that it lacked any information detrimental to the creditworthiness of any customer and left blank how much of its outstanding customer debts were over 60 days past due. The policy contained a provision excluding coverage based on a misrepresentation. Magna Tyres USA obtained coverage for multiple companies, including 3 for which it eventually submitted claims: Tiger Direct, Inc., Narcy, Inc., and Tire Supercenter of Orlando, LLC. Before the application was signed, Magna Tyres USA knew that Sanjit Singh Veen owned 3 companies whose debts exceeded $11.6 million. Magna Tyres USA's former employee, who oversaw accounting, testified that Singh was regularly 90 days past due on his accounts. And in January of 2020, at a meeting, Magna representatives stated that Singh's debts created, quote, too much risk, close quote, and decided to stop shipping products until he paid his outstanding debt. Alexander Lecroux, Chief Underwriting Officer for Coface, stated that Coface would not have insured the debts of any Singh company had Magna Tyres USA disclosed that there was one person responsible for the customers' orders, that the customers were heavily indebted and had debt that was 60 days past due, and that Magna Tyres USA had stopped delivering products to that customer based on the debt. Magna Tyres USA submitted insurance claims to Coface, seeking coverage for the unpaid debts of the covered companies, some of which Coface held in abeyance and some of which it denied. Magna Tyres USA sued. Coface answered that Magna Tyres USA made material misrepresentations on its application. The district court granted summary judgment in favor of Coface, who appealed. The district court did not err in ruling Magna Tyres USA made a material misrepresentation, concluded the 11th Circuit. Magna Tyres USA misrepresented in its application that it lacked any information detrimental to the creditworthiness of any customer, and in fact, Magna Tyres knew information detrimental to the creditworthiness of the covered companies when it signed the application in February of 2020. A party to a contract has a duty to know the contents of the contract before he signs it, and know the contents of an application for insurance before it's signed, regardless of whether an insurance agent completes the application or not. Michael de Ruijter signed the application and knew all the information regarding Singh's payment history with both Magna Tyres USA and Magna Tyres Group. The misrepresentation was material. Florida courts have held that the determination of materiality to the acceptance of a risk is a question of law based on the objective view of materiality, and the determination of how the insurer would have acted is one of fact requiring testimony from the insurer's representatives. The failures to disclose that Singh was the common owner of the companies and had amassed debts sufficient for Magna to stop shipping based on the risk of non-payment were objectively material. LaCrue was designated to testify as a corporate representative regarding the procedures for evaluating the buyer's credit risk. An insurance company has the right to rely on an applicant's representation and is under no duty to inquire further unless it has actual or constructive knowledge that the representations are incorrect or untrue. Coface lacked knowledge about Singh's companies having such high debt that Magna Tyres stopped shipping to them before obtaining coverage. Coface was entitled to rely on the truthfulness of the application that Magna Tyres USA had no information relevant to the customer's creditworthiness when in fact they did. In my opinion, this is not a rescission case. It's simply a breach of contract, and although Coface could have rescinded the policy, it did not. It denied the claim based on misrepresentation and left the policy in effect to pay honest claims. Magna Tyres lied on its application, knew it had a customer with a major bad debt, and only after the policy was issued attempted to collect the debt from the insurer instead of the customer. It let go deep into such debt. Insurers are entitled to rely on the good faith of an insured, and when lied to, the insurer can refuse to pay. Technically, the major lies for Magna could even have been evidence of fraud. This video is adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, please find that you will have notice of every blog posting, usually 5 or 6 a week, and access to the more than 5,050 blog posts. You can also subscribe to these videos. They too are free. And if you do, I'd appreciate it if you click on the like button for YouTube and the thumbs up button on rumble.com. And please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.